very good afternoon to you, our cherished and descending listeners. It's another beautiful and blessed Wednesday, and we're happy to bring you another exciting edition of your favorite business development program on radio, Masterclass. Masterclass is powered by Joy Business and brought to us by Goyle. Goyle Good Energy, Goyle Yenara Yedia. Masterclass is also brought to us by Lancaster University. They boast of having the only British university campus in all of West Africa. If you're looking for some tertiary education, by all means do consider Lancaster University. Masterclass today is also brought to us by GCB. GCB, they say your bank for life. My name, as always, is Barnafo, and I'm excited to be back here on your radio and also streaming live on Facebook to bring you today's edition of Masterclass. Last week, we started a rather interesting conversation, and it was essentially in the area of claiming credit balances of a beloved one when they're deceased or when they're demised, and what processes you go through. It was an interesting conversation because we know that it speaks to the issues at heart for many people, and a lot of people have had similar experiences, and they have either been able to resolve or not been able to resolve some of the issues. Some still have outstanding issues, and last week we were privileged to have with us here in the studio Mr. John Adama, Executive Head of Retail Banking, GCB. He's back here again in the studio with us. John, I'm excited to have you back here on the show.
Thank you. I'm excited to be here again.
I was hoping and praying when we were rounding up last week that the production team would be able to oblige us so that we could continue our conversation today, because there were so many unanswered questions both on social media and also on the phone lines. And thankfully, we're back here today. Yeah. We'll go straight to it. I'll try and save a lot of the time today for the content that we were unable to deliver last week. But by all means, if you're listening to us, if you just tuned in, this is Masterclass. The conversation from last week continues today. Tell a friend to tell a friend. By all means, do make sure that you listen to today's program. When we get interactive, let's get your questions. You can also send your questions to us on our WhatsApp line ahead of time, so that once we get interactive, we can read them as well and try and find answers for them. We're also streaming live on Facebook for those who like to follow, and we'll be sharing some slides which has a lot of information on it. Also, do stay tuned and by all means be a part of today's conversation. Off air, just before we came in, we're talking about the question from the first caller last week. So perhaps we'll use that as an introduction and a quick recap. Yeah. Then let's go straight to your content for today.
Yeah. Thank you very much, Yao, and good afternoon to our viewers and listeners. I think that question was from Stella.
I think it was Stella.
Buchui.
Yes.
Yes. And Stella said the dad died in January 2013, and then they went to the bank to find out if there is any balance in the dad's account, and they were told a loan had been taken by someone in November 2014. And I was wondering how this could have happened. And so I think I didn't get the question right on the day, but thankfully we have the opportunity to clarify. Now, once their dad died in 2013, there was no way their dad could have applied for a loan
in 2014. That's correct.
Yes. So that matter should not be just allowed to rest. If the bank, she said a commercial bank, if the bank is GCB, she can take my number from the producers and get in touch with me. If it is not GCB, they should go back to the bank and engage the branch manager, because they should be able to produce evidence to actually tell who actually took the loan, because someone may have applied for the loan. So their dad's account balance, if there was any at the time of death, should be available for them.
And I just quickly add that the family lawyer can help them in this.
Yes.
Normally in things like this, it's also good to have representation from persons who know what they're doing and persons of renown who understand the process also. Because if you go there alone and they tell you one thing and you don't understand how the process works,
yes, you
are likely to take whatever they tell you, hook, line, and sinker, and walk away.
Yeah.
But we're looking at doing things right. It's not about putting anyone in trouble.
Yes.
It's about doing things properly. It may even be a learning point for whichever institution it is.
Yeah.
Perhaps there maybe have been an oversight.
Yes.
There may have been, a misdeed.
Yes.
Whatever the situation is, it's important to go through it properly and get the kind of respite that is required.
That's true. That's true. And banks like feedback, so they should get back there and pursue the matter further.
Indeed.
Yes.
I hope that Stella joins us again when we get interactive today.
Yes.
But just a quick recap. What did we do last week?
Yes. So last week we were looking at the various type of accounts that a customer could keep at a branch, and what the legal implications of those accounts were, and what would happen in times of death. So we looked at a personal account, an account operated by one individual. We looked at a joint account, an account operated by 2 or more individuals. We looked at a sole proprietorship, which is a business organization registered and operated by one person. And then we looked at limited liability companies, which are bodies corporate. And then we stated that the treatment of a deceased person's account balance, if it is a sole proprietorship and an individual, would differ from when it is a joint account, a partnership, or a limited liability company. So for today, what we want to actually look at is the processes leading to claiming balances of sole proprietors and individuals. Last week I touched on partnerships, I touched on joint accounts, and I touched on limited liability companies. So today we would look at the processes, and the processes as would apply to sole proprietorships and then individuals.
Very, very good information coming your way in a few minutes. Let's take advantage of it. Like I always say on Masterclass and here from Joy FM, we give this information to you pro bono. You'd have otherwise had to pay for this kind of information through a course or something of the sort. But here is Mr. Adama, who has taken time out of his busy schedule so that you can learn and become better. Because when you are better, your businesses are better, Ghana becomes better, and we all become better for it. So let's take note. Make some notes if you will. Go back and play the video if you will. But by all means, do join us in this conversation.
Okay.
Yes, John, go ahead.
Yeah, so there are 2 categories of disease customers that a bank would have to deal with. There is a category that has died, test it. And when we say a customer has died, test it, it means that the customer wrote a will whilst alive or executed a will whilst alive. So if that person subsequently dies, that person would have died tested. So dying tested means you have written a will whilst you are alive. There is another group that may die intestate. If you die intestate, it means that you have died without writing a will. So your wishes after death have not been expressed in writing. And so you have died intestate. Now, if you have a customer dying testate, it means that the person in his lifetime had actually appointed someone who would manage his estate when he's dead, when he's gone. And that person that is appointed to manage the deceased's estate, and which appointment is actually made in the will of the person, is an executor or executors. You can have between 1 and up to 4. Now, if the person dies and had not written a will prior to death, that person had died intestate. And what it then means is that persons who are entitled to his estate may have to apply to the court for letters of administration. So the authority to administer the person's estate is derived from the letters of administration that will be granted by the courts. And so what you need to do, so assuming that your deceased relative had died intestate, which is the majority of the cases that we have. Unfortunately, most of us do not write wills. And so most of the cases that you would meet in practice are death intestate. Now what you do is you would have to get a lawyer. In fact, in these matters, you have to get a lawyer. Your branch manager will advise you, but there are some things that are reserved for lawyers. So you may have to get a very good lawyer, and the lawyer would apply to court for letters of administration to be granted by the courts. And when the lawyer is doing this, the lawyer will be minded by a few things. The lawyer would have to be sure that you have a claim. I mean, you are entitled to the estate of the deceased. Now, when letters of administration can be granted by the court, from the point of jurisdiction, when I say jurisdiction, the courts have the power to grant, certain applications, and you have to apply for the letters of administration. It is done through an application, and so the lawyer who is doing this work for you will have to be minded by the jurisdiction of the court. So if you have an account balance in Tamale to claim from a bank, and let's say your dad died in Accra, now you can, the rules provide that letters of administration can be granted in the area where the person has an estate to claim, or at the place where the person has his last place of abode. So if your estate is in Tamale, let's say the account balance you want to claim is in Tamale, meanwhile your relative died in Accra, the last fixed place of abode is in Accra, you can obtain the letters of administration either in Accra, in a court in Accra. A court in Accra has jurisdiction to grant the letters of administration, or you can take it where the asset you want to administer is situated, and in this case, Tamale.
So I just want to clarify that quickly.
Yes.
To apply for letters of administration,
yes,
it must either be where the person passed on,
yes,
or where the asset is situated.
Exactly.
What if the person passed on in a location other than where the assets are located?
Yeah, so
which takes precedence?
No, it is not about precedence here. It is about convenience.
Right.
So, the courts have jurisdiction over amounts that they can deal with. So, for instance, a district court cannot grant letters of administration exceeding 500,000 Ghana cedis. So, if the estate that is to be administered, let's say, is in Tamale. Okay, Tamale has a high court, so that is not a problem. So if the person dies in an area where you have just a district court, the circuit court can go up to 2 million. So if you have a district court there, and then the estate is more than that, more than the limits of the district court, it means that you can't take the letters of administration from that court. So you may have to probably go to a circuit court or maybe a high court. So the jurisdiction comes in depending on the value as well, and then apart from where the asset is to be administered, where the person's last fixed place of abode is also at play. So it's either where the asset is or where the person actually had his last fixed place of abode.
Whichever is convenient.
Whichever is convenient. So its convenience is the word. Yes.
I wanted to make that clarification.
Yes. So convenience is the word. Now we have talked about the jurisdiction. So in terms of the financial jurisdiction of the courts, it's also key. But all these things will be sorted out by the lawyers. Now, when the letters of administration are granted by the court, you would have to send these letters of administration to the bank. And banks would want to see the original copies, the originally sealed copies of the LA. And last week I did make the point that there is something we call a citation. Now, between the time that you have applied for the grant of the letters of administration and the time that it is sealed and granted, someone can enter a caveat. A caveat means it's challenging your authority to be granted the letters of administration. But after the grant has been made, then you can only enter a citation. A citation means that you are challenging the person's authority to be granted. The person has already been granted the letters of administration. So what you do is that you enter a citation, you serve a notice, and then the person will have to deposit the original copy of the letters of administration at the registry of the court.
Right. But the citation can only be done after the LA has been issued.
After the LA has been granted. After the LA.
Is there a number of days after which the LA?
Any time after the LA has been granted, you can, if you want to dispute the grant, you can enter a citation.
Okay. So I'm tempted to ask this now.
Yes.
Just so my listeners are clear.
Yes.
So an LA, a letters of administration,
yes,
or an LA is issued.
Yeah.
The estate is administered. Then somebody comes along and says, I was abroad when this was done. I wasn't here.
Yeah.
I've just found out.
Yeah.
6 months later.
Yeah.
Can they enter a citation at that point?
No, you can't, because once the estate has been administered, you said the estate has been administered.
Yes.
Time is of the essence here.
Right.
You know, there are other penalties that go with. There's something you call intermeddling. If you are not entitled to the estate and you go get letters of administration to administer the estate, you are in breach. You will be said to have intermeddled with the estate, and there is a penalty for that you can be taken on. But I'm talking of a situation where the LA has been granted, the estate has not been administered, and then people who feel entitled and have been excluded have gotten wind of that. So they can, you know, there's what we call an administration action or probate action. You go to court, and before you file your writ at the court, you would have to serve a notice on the persons who have been granted the LA for them to deposit the original copy at the registry.
At the registry.
Yeah, before the processes would continue. And so if you come to the branch and the branch is asking for the original copy of the LA, they are not asking for anything that is you know, out of this world. They just want to be sure that probably there is no dispute over the estate and you have deposited the original copy, because you still hold on to certified true copies anyway. They give you a number of certified true copies. So if you bring the certified true copy and they have not seen the original copy and they go ahead to use the certified true copies, probably a citation may have been filed or may have been served and you have deposited the original copy.
And at that point, as a bank, you would be helping to perpetuate
further
the breach.
Yes.
Which is now in contention.
Which is, yes, because you have constructive notice that probably there is something wrong. I mean, notice is not always actual. There is constructive notice. So you would have to ask questions, and if they cannot produce the original, probably something like that may have happened. And that is why banks would ask for the original copies of the letters of administration.
Interesting. Let's continue.
Okay. Yeah, so once the LA has been presented, the banks would want to be sure that the persons named as administrators are actually the administrators that they are dealing with. So they would want to identify you. And so normally you may have verifiable photo IDs just to identify
proof of ID, they call it.
Yes, proof of identity. And we say they should be verifiable because we want to be sure that this is not a NEMA or Newtown produced ID card.
These days, your Ghana card will prove very useful.
Very, very useful. and yeah, very, very useful. So the banks just want to be sure that they are dealing with people who are entitled to the estate. And that is why they will ask for your identity. In some banks, they may even take a passport picture from you and all that. Now, if we can have as many as 4 persons who are administrators, I think I did mention the last time. Yes. Now, if for some reason, let's say only one of them is available, the others can grant that person, the one person, power of attorney for him to administer the estate on their behalf. In fact, from the position of law, the fact that you are an administrator doesn't mean that the money in the account belongs to you. So if one of the 4 is the one available and the others can grant powers of attorney, they can't grant powers of attorney to the 4th person to administer the estate. So in that case, the bank will not require all 4 to be present for the account balance to be disposed of.
Right. But that is if the administrators are more than one.
If they are more than one.
So that in cases where there's only one administrator,
yes,
let's say the family agrees and says, listen, the eldest son,
yes,
or the eldest person in the family, you would represent us.
Yes.
You have led every arrangement. So
yes,
you would go to the process
yes,
of acquiring the letters of administration.
Yes.
In that case, it's only you who is the administrator.
It is you who is the administrator.
And therefore, no power of attorney is required.
At all. No power of attorney is required.
Because it's assumed that conversation takes place before you went in to become the sole administrator.
Yes. No, the court, before granting the letters of administration, have a process. And once the court is satisfied with the processes and have granted the letters of administration, you derive your power from the letters of administration.
Right.
So the bank will deal with you. The only time the bank may require powers of attorney may be if the appointed administrator is not the one who is present at the bank.
Right.
Yes.
Right. Right. That makes sense.
Yes, it
That
does.
makes sense.
It does make a lot of sense. It does make a lot of sense. So, to conclude the administration, it is not always the case that the administrators would get the account closed and they take the money and go away with the money.
I'm going to share it.
Yes. You can open an administrator's account. And so for people who have died possessed of large estates, you may have to accumulate all the the properties, maybe convert them into cash, pay some some debts and all that, and then distribute the residue to people who are entitled. So you can open an administrator's account, and then the deceased's account will be closed, and then the balance in the account will be deposited in the administrator's account, and then you can run that account until you dispose of the estate.
Okay, so again, another important piece of information here.
Yes.
If you are the Busiapeni, or you are the eldest person, or you are the one selected by the family to represent the process of letters of administration, what we are saying is that you don't necessarily have to empty the account and hold cash. You can also open what you call an administrator's account, because clearly, if there's more property or more estate, you may want to, or it may be a family decision to liquidate same and put the proceeds in a certain account. Sometimes there are children who are left over, and the decision of the family is to take care of the children up to a certain age. The bank provides, as part of this process, for you to open what you refer to as an administrator's account, and then you manage the rest of the process from there. And it's good for you because then you can have bank statements, you can have transparency, and you can easily show people that you are not misusing the funds, which is sometimes the bone of contention when some of these things occur.
Yeah.
It's absolutely important that we make that point.
That's
Please
true.
proceed.
Yes. So we've done with administration, where you would have to obtain letters of administration and go through the processes I've described. Now, when it is death testate, meaning that the person has a will. Now, this person has appointed an executor, and that executor has the authority of the deceased. I mean, this is the only situation where...
You notice I'm smiling.
Yeah, you are smiling, yes. I can
I'm
see
smiling because I just chipped this one in.
Yeah.
This conversation is sometimes a bit terse and a bit morbid.
Yes.
So there was a case, very, very, very quick one. There was a case that happened. The person died testate.
Yeah.
And they had a will.
Yeah.
And there were people who were around who expected to be the ones who were named for the big properties.
Yeah.
So they show up, and then the lawyer sits there and says, "Oh, by the way, so and so person died, and he's left all his property to Amma."
Yeah.
And the person says, it's me, I said it. He said, but you are Kwame. He says, it's my female name.
That's an interesting one.
And that tells you how people clamor.
Yes.
And that's why the process is important.
Yes, yeah. I have seen in my practice, I've seen so many things. Some of them emotionally draining. I mean, so I think wills are not devoid of controversy, but they are far, far better than when you do not write a will.
But can a will be questioned? Anyway, let's keep this question honest. Can a will be questioned by the people to whom it is read?
Of course, a will goes through a very delicate execution process. You miss a step and the will is invalid.
We'll get there.
Yes.
Please start from where you are now. Let's get there.
All right. So we are looking at death testate, where the person during his lifetime had written a will before death. So here he appoints an executor, and this executor would have to apply for probate. So they go through a similar process, a process similar to the one that you go through to get letters of administration.
Right.
Yes, but here the will is there, so you'll be granted probate, which you would annex to the will, and then it is that probate that you present to the bank. So the executors will present the probate with the will annexed to the bank, and based on the strength of the probate, the bank will deal with them. The other advantage of a will is that if you look at banking thrives on banking confidentiality. So if you look at the Banks and Specialized Deposit Taking Institutions Act 930, you look at section 146 subsection 2, it imposes a barrier on how much information a bank can disclose about a customer. Section 4 of Section 146 provides exceptions. And one of the exceptions is that the bank can deal with the appointed administrator or the testamentary executor. Meaning that if you are named as an executor in the will of the deceased, you have been appointed by the deceased. So it makes it easier. So you can walk to the bank on the strength of that will. The bank identifies you as the executor, and every information that you require on the account, even prior to application for probate and all that, the bank would be able to provide that information.
Right. But if you are so named by the will,
yes,
as executor,
yes,
do you still require a probate?
You require a probate.
What is a probate?
A probate is a document that is issued by the court to enable the executor to administer the estate of one who dies testate.
So you cannot walk straight to the will. You must necessarily be issued with a probate.
Yes, you
That
must.
then gives you access.
Yes.
To the will.
Yes, please.
But of course, this is within the remit of the lawyers.
The lawyers.
Therefore, if you have a family lawyer
yes,
who's handling your process, they
yes,
will know what to do.
Yes, they will know how to do.
Brilliant.
You know. So once you have the probate now gives you the fuel. So let's say that the will is just the firewood, and then the probate gives you the spark to set it into motion.
To ignite it.
Yes, to ignite it into action. So once you have that probate, then you can deal with the estate in a similar way as we have described for people who are granted letters of administration. So you go to the court would want to see the originally sealed probate, and they would want to identify you, and then you go through the process. They will close the account and pay over. Similar points as we have made for powers of attorney and all that could also come into play, and then eventually the account of the deceased would be closed, and then either the cash will be paid out or a probate executor's account will be opened with the probate as a source, similar to letters of administration. Administrator's account.
Right.
And then the account can be operated.
So whereas a letters of administration account would be administered by a sole named administrator,
yes,
an executor's account would be handled by a sole named lawyer or executor.
Okay, so this is how it works. If you have 4 administrators, they would administer the estate. If you have 4 executors mentioned in the will, and the 4 executors have all agreed to administer the estate, they would be granted the probate. So the 4 would act.
Right.
The 4 would act. I don't know whether you get the difference. Yes.
Get it.
So whether you are an administrator or administrators or executor or executors, you could be 1, you could be up to 4, and you could all act.
And there are processes for that.
Yes.
Right. I think we'll get interactive, and then while we wait for the comments to come, we'll keep sharing some additional information.
Okay.
This is Masterclass here on your superstation Joy 99.7. We're sharing some wonderful thoughts here on how to claim the bank benefits or credit balances of loved ones when they're deceased or demised. That process is torrid for many people. Some have walked away from it. Some are emotional. It's a sore area of conversation for a lot of people. But today we're sharing information on how you could possibly go back and resolve that process so that you can have the respite and closure that you require. We'll take a quick message from our sponsors. When we come back, we get interactive. We'll take a quick message right now.
Your favorite on-air business development program, Joy Business Masterclass, is in session, and you can interact with us on Facebook via the Joy99.7 FM or Joy Business pages. If you tweet, the handle is at Joy997 FM or at Joy Business GH. Don't forget to hashtag JB Masterclass. You can also call us on 0302 216541 or send your questions and contributions through to the WhatsApp number 0551 111997, and our facilitators will address your concerns. Attention everyone, class is in progress.
Welcome back. If you just tuned in, this is Masterclass here on your superstation. We're getting interactive right now as we talk about claiming the credit balances of loved ones who may be deceased or demised. Last week we started with this conversation, and thankfully we're able to bring it back to you today so that we can exhaust all of the content that is involved in that conversation. Today we're interactive right now. Numbers to call 0302216541. You can also send us your comments on 05511119997. Do you know someone who has been through that process? Have you been through that process? What were your learning points? How can we all learn from that and become better for it? If you've got any motor vehicle of any kind, I've got some great news for you. GOIL is rewarding all its prepaying Go customers with 2% discount per litre on all fuel purchased. You can also enjoy discounts on lubricants at GOIL stations nationwide. Elevate your goodness by joining the GOIL Go Club today and enjoy up to 3% litre discount on all fuel purchased. GOIL, good energy. GOIL, Yenara, Igedia. So live the stress-free life with GCB's personal loan. With GCB personal loan, salaried workers can meet all their financial obligations with a smile. Whether it's educational fees or urgent medical expenses, whether it's the pop-up expenses and bills or home makeovers or even renovations, or it's that vacation you've been waiting for or that holiday trip that you want to give your family. By all means, do go for the GCB personal loan and you can access this for yourself. Visit any GCB branch today or call 0800 422 422 for a GCB personal loan today. GCB, your bank for life. We're interactive right now. Numbers to call 0302216541. You can also send us your comments on 05511119997. By all means, to pick up that phone, give us a call. Let's hear your thoughts. I've got this one from KB from northeast of West Hills Mall. Hey KB, now I'm confused. The northeast of West Hills Mall. It says, okay, my uncle before his death, he gave his GP. Okay, he asked his GP to sign on his savings account due to ill health. His daughter has been drawing funds on the balance for the last year. Is she right to be drawing funds on his balance, and why? Can I take legal action against her? Okay, so KB's uncle has passed on due to ill health. Yeah. He asked his GP to sign on the account. Yeah. But since his uncle passed, his uncle's daughter has been drawing from her father's balances. So KB is asking whether his uncle's daughter is right to be drawing.
She's not right. She's intermeddling with the estate of a deceased. In fact, whatever authority she had to pay the account terminates when the uncle died.
No, it is KB's uncle who has died.
Yes, KB's uncle has died.
The uncle's daughter is the one drawing on the account.
And drawing on the dead uncle's account.
That's correct.
Yes.
So it's like drawing on her father's account.
Yes, but that is the father's account is not her account.
Please listen,
Yes.
We are educating ourselves.
Yes.
If and when, God forbid, your father passes.
Yeah.
It is not automatic that you can draw on his account.
At all.
You say he was my father.
Yes. It's not...
So why is it wrong for her to be doing that?
Yes, the account contract, as I said the other day, is between the uncle and then the bank. And we have said that once the uncle died, any mandate he has given to the bank is terminated. Now, even if the daughter was signing, let's say, a power of attorney or a third-party mandate, with the death of the man, that authority is terminated.
And must necessarily, if he died intestate, go through the intestate process.
It must go through the process.
Tested, must go through the testing process.
Yes.
If it was a company account, it must go through the company account process.
Exactly. And she might not be the only person who may benefit from the estate of the deceased. There might be other people.
Please,
she's intermeddling with the estate.
Let's listen and learn. Yes. And let's not get emotional for nothing. So KB, according to our information, the process has not been followed.
Yeah.
Let me say it that way. The process has not been followed. This one is from Dan. Dan, you didn't tell me where you're sending me this from. It says, what if the person died intestate and you were named next of kin? I'm assuming named next of kin where? Because the person's intestate.
Okay.
So there's no will.
Yes, there is no will.
So the family named you next of kin.
Yeah, so, there is a chain of succession. I mean, a class of successors to somebody's estate. Elsewhere, the succession laws allows for nominees and next of kin to have access to a deceased person's estate as of right, especially account balance. But here, our succession laws are different.
When you say here, you mean Ghana?
Yes, Ghana. So you may have to go through the process.
So Dan,
and this case,
did this occur in Ghana? If he did, it must go
through
according to our processes here in Ghana.
Exactly.
And according to our processes,
they've intestate, so he may require letters of administration.
Okay. All right.
Yes.
So Dan, that's your answer right there.
Yeah.
I've got some more comments on social media. My phone lines are still open. I'd like to hear your voice as well. 0302-216-541. But I love your comments on social media. This one is from, is it Albusha? Please do me a favor. Don't call me on the WhatsApp line. Send me a message. The WhatsApp line is 055-1111-997. Send me a message on that. But if you want to call me on 0302-216-541. If you're calling from outside of Ghana, you add the country code +233. This one is from Al-Bashar in Toronto. He says, my father's will had my older brother and his nephew as executors. Meanwhile, his nephew died, but the nephew died intestate. The probate was granted to my older brother, who now becomes an executor.
Yeah.
The chiefs of the area took my sister to court, stating my dad's building is on a leased land.
Okay.
Even though at the purchase of the building, yes, the land was under lease, my dad did pay for the land and later got a receipt to prove it. What can my sister do in this case?
Okay, so let me get it right. So there were two executors.
Yes.
There were two executors.
Let's go back to that point again.
Yeah.
So he says my father's will had my older brother and his nephew as executors. So there were two executors.
Okay.
Meanwhile, the nephew died.
Leaving one.
But the nephew died intestate.
Yes.
The probate was granted to my older brother. So now there's one executor who now becomes an executor.
Yes.
So now there's one executor.
Yeah.
The chiefs of the area took my sister to court, stating that my dad's building is on a leased land. Even though at the purchase of the building, yes, though it was on a leased land, my father paid for it and later got a receipt to prove it. What can my sister do in this case?
No, you should get a lawyer, because in terms of the person who has been granted the probate, I think that is perfectly right. Because there are two executors.
One passes.
One passed. The subsisting existing executor has the power to admit the will to probate, which has been done. The issue about the land and the payments and all that, I think those.
So I think they're trying to draw an analogy from the fact that
Yes.
it's the executor's sister who has now been taken to court by the chiefs.
Yeah, but the issue is about the land, and I'm sure the land forms part of the estate.
That's correct.
Yes, so they would have to fight that case. It has nothing to do with the general executorship. It is about the land, and I think that they will need to fight.
And
that.
the executor must do the distribution based on the laid down procedure.
Yes, he has a power. He has a power under the law to do what the deceased would have done if he was alive. So if there are actions to be taken and all that, he will do that, and they'll continue with the executorship.
Okay, I've got this one is from Kobe from Koforidia. He says, please, if a spouse who is a named beneficiary, a spouse who is named as the beneficiary of a will of a husband dies before the husband, what happens to the estate left to the spouse who died earlier?
The spouse is named as a beneficiary.
Yes.
Of the will.
But the spouse dies before the husband.
Oh, there is a.
Then what happens to the estate left to the spouse who died earlier?
You know, in an estate there is what we call residuary estate. So this one, he predeceased the testator. So that gift will lapse. It will fall into residue. There is a residuary estate, and sometimes it can even be administered in line with PNDC law 111. So you should see a lawyer.
Okay.
Yeah.
A lawyer knows what to do.
Yes.
Please talk to a lawyer.
Yes.
Right. I've got this one. Is you didn't add your name. It says, good afternoon. What is the process of acquiring letters of administration? I think we talked about that, but briefly, can you just repeat?
Yeah. So it is the work of a lawyer. You will need to get you will need to get a lawyer. The lawyer would apply to the court, and there are processes to follow. The court will do an exhibition to find out whether there are anybody who would contest the grant, and then once, after a certain number of days, once there is no protest, the court will go ahead to grant. So if you see a lawyer, the lawyer will take them through the process.
Okay. In these matters, the lawyers know best.
Yes.
So please see a lawyer. Do I have any more comments on social media? Okay, I think I have a few comments on Facebook.
Okay.
I think those are coming through now. Right. It says, thank you for your response. I still have a few more minutes to pick up a call. Numbers to call 0302-216-541 541. There's a question here that I have. Let's see if we can quickly just. Can a will be challenged by the people to whom it is read?
Of course, a will can be challenged, and there have been several wills that have been challenged. And there have been some funny wills. I mean, there were wills in which the testator actually refused to give part of the estate to even close members of his family, including his children. And sometimes the execution of the will could be challenged. I mean, the way the signature even of the testator could be challenged. So there are several ways by which a will can be challenged. A will can be challenged.
And when it is, it goes to court.
Yes, you have to. That's why we have a probate action.
Right.
You go to court.
Okay, I have a caller on the line. Let's take that quickly. Good afternoon. You're welcome to Masterclass. Your name and where you're calling from.
Good afternoon. My name is Henry. I'm calling from Accra.
Good afternoon, Henry. Talk to me.
Please, sir, is it possible to have your resources number to be in the forum?
Yes, we will put the number out at the end of the show, Henry.
Okay.
Yes, please keep listening. I've got Carol from Accra. Carol says, does a probate come sealed?
Yes, it has to bear the seal of the court that issued it.
Okay. So I don't know whether the word sealed there means enclosed and marked or
no, there is a court seal that is usually embossed in there.
Interesting. Yeah. Okay. I have another question. What is the distinction between letters of administration and the provisions of the intestate succession law?
Okay, so
okay, please hold that question for me. I've got another caller on the line.
Okay.
Good afternoon. You're welcome to Masterclass. Your name and where you're calling from.
Yeah, this is Benjamin from Adenta. I want to find out, there was a case where the gentleman put somebody as next of kin on his account. He died. The wife knew the account he was operating. He didn't even tell the next of kin. And the wife informed the guy because she went to the bank and it wasn't possible for her. So she had to go and inform apparently the brother of the deceased. The brother of the deceased came to Accra, went to the bank, withdrew everything, and left without giving the wife anything. Is there situations where those things can change? Because sometimes, as a young employee, you probably wasn't married, therefore you put somebody there as your next of kin. You might have forgotten to take it off, or even something can happen. So are there instances where those things can be challenged? I want to find out from your guests. And also, there are so many people who die, and sometimes their families are unaware of their bank accounts. I mean, how do the bank trace those? Because you can't have everything 100%. And those funds, what happens to them? Do they go to individual bank managers, the bank itself, the CCCs, or what happens to that? Thank you.
Interesting question. Please keep listening. We'll try and answer them. So, number one, did the guy do right?
The guy didn't do right. The fact that you have been stated as a next of kin does not entitle you to the account balance when the account holder is deceased. As I've indicated, our succession laws will kick in, and you may require either a probate or letters of administration.
So the question is even how did the bank allow? A lot of questions need to be asked.
Yes. The bank shouldn't have allowed it. I mean, once you die, as I've indicated the last time, once you die, the mandate you have given to the bank is terminated.
Please listen. Don't hide. You have money. You are hiding it in some account. And it brings us to the next question. Yeah. When you die, the laws of Ghana, they prescribe how those funds should be treated.
Yeah.
And if you don't tell anybody about it, there's a way it's treated.
Yeah.
How do funds of people who pass on, who haven't told their family and nobody knows, they want to know whether it goes to individual bank managers?
So let me take advantage of this to clear this up. Before the passage of Act 930,
and as you do that for me, my team is signaling me. Let's sort of summarize today's conversation and round up, if you will.
Before Act 930 came into being, when the president was signing this law in 2016, he was signing a certain section 143 of that Act 930 into action, and that is unclaimed balances provision. And pursuant to powers granted to the Bank of Ghana, they brought in the unclaimed balances and dormant account directive 2021. And per the provisions of that directive, which is in accordance with section 143 of Act 930, dormant account balances, which includes deceased accounts, I mean, would eventually have to be transferred to the Bank of Ghana.
I like the way you said it. Let's not even add anymore.
Yes.
You asked where the money is. It's at the Bank of Ghana by law. Let's end it there. Please, what should we take away from this conversation?
Okay. Yeah, so this conversation, since last week, has been centered around how we can assist relatives of deceased customers to get access to the bank balances of their deceased relatives. And so we've looked at two situations. A customer may die testate or die intestate. If you die testate, you have died writing a will. And you would have appointed an executor who would carry out your wishes after you have died. The executor would have to obtain probate from the court to be able to administer your estate. If you die intestate, you have died without writing a will. And those who are entitled to your estate may have to go to court and apply for letters of administration. I made mention of the financial jurisdiction of the courts. I said that the district court could grant up to 500,000. The circuit court could grant up to 2 million.
Yes.
And then, so if the estate is beyond 2 million, you have to go to the High Court to obtain either probate or letters of administration. But what I want to leave with listeners is that I think there must be some honest transparency attending our bank, our dealings with the bank. Now, there are several accounts we have today that have no contact details of anybody on the account. Even the account holders themselves have not come forward to update the account information.
To refresh your data.
That must be done. In fact, even if you have a contact person's contact details on the account, the banks now are going after, these dormant account balances and all that. And they are finding it difficult because of the paucity of the inadequate information. Yes, we have.
Thank you so much. I promise to put the number out. If you want to reach my resource person after here and try and get some help, the number is to call 0244 885546. That's 0244 885546. This has been Masterclass here on your Superstation Joy 99.7. Next week, God willing, we have the privilege of spending time with the Chief Information Security Officer of GCB, Mr. Ronald Marty, and he will be talking to us about the 10 things organizations can do to stay protected in this digital age. My name is Barnafo. Thank you so much for staying with us. We'll see you same time next week. Up next,